Good morning, everyone. Welcome to today's hearing. Today, as yesterday, I'm taking part in the proceedings from a remote location because I'm afraid I've tested positive for COVID. Today, we're going to continue hearing evidence from Mr. Brian Martin. So if Mr. Millett is ready, I'm going to ask him to invite the usher to call Mr. Martin back into the room, please.
Yes, thank you very much, Mr. Chairman. Could we please have Mr. Martin back in the hearing room?
Good morning, Mr. Martin.
Good morning, sir.
You can obviously see me and hear me, judging by your response.
Yes, sir.
Good, thank you very much. You're ready to continue, I hope?
Yes.
In that case, I'm going to invite Mr. Millett to put some further questions to you. Yes, Mr. Millett.
Yes, thank you very much, Mr. Chairman. Good morning to you. Good morning, members of the panel. Mr. Martin, good morning to you. Now, you may remember last night when we finished with your evidence yesterday, we were examining the 2005 consultation, which led to the 2006 amendments to ADB published in April 2007. Can I go back to that topic, please, and start with CLG 6025. This is the proposal for amending Part B, Fire Safety of the Building Regulations consultation document dated July 2005. What was your role in putting this document together?
So I had, I guess, a coordinating role, bringing various draft texts together, drafting some of the text myself, managing the process of discussing various proposals with the BRAC Working Party, and really bringing all the various bits of evidence together, right. And eventually developing this draft.
Which parts did you draft, from recollection?
I had a role in drafting and in at least looking at all of the various draft bits of text in there.
I see. But was there any part of the text for which you had a primary role, which you drafted from scratch?
Difficult to remember. It was a very big project and lots of different people were contributing to it. I think I did quite a bit of work on means of escape guidance for care homes is a bit I particularly remember drafting.
Right. And who else in principle did the drafting? When I say in principle, who mainly did the drafting work, other than perhaps you?
It was a collaborative exercise between myself, officials in the department and other colleagues at BRE. Dr. Colwell had completed a contract that the department had commissioned reviewing the guidance on cavity barriers to try and improve the clarity of that. So she contributed a significant chunk of work to that. I think another colleague at BRE had done some work on fire dampers. And again, they produced some draft text, which I then sort of edited into the main draft.
Who did the main work on what became Section 12, external wall construction?
Probably myself and Mr. Bird would have been the main people working on that.
Right. Anybody else?
Not that I recall.
Now, can we go to page 9 in this document, please? Paragraph 15. And it says here, the most significant changes the government intends, in bold, to make include, and then you can see some 7 bullet points. And if you cast your eye down, they comprise smoke ventilation of common access areas in apartment buildings, additional smoke alarms, a suitable system of smoke alarms, cavity barriers, inclusive design, national maximum unsprinkled compartment size for warehouses, and compartment walls to take account of deflections during a fire. You see that?
Yes.
It's not an exhaustive list because it says it includes, but it doesn't include any reference to the provisions in B4 relating to external fire spread, does it?
That's correct.
No. And if you look at paragraph 16, we can see a list of the provisions the government is minded to introduce, as it says in bold there. And again, there's a longish list below that: sprinkler protection, fire protection of corridors in self-storage warehouses, firefighting shafts, dry rising mains, phased evacuation procedures, and removing separate guidance on loft conversions, and then finally self-closing devices within apartments and dwelling houses, except in garages and common escape routes. Again, no reference there to the provisions in B4 relating to external fire spread, is there?
That's right.
Why does neither of these paragraphs contain any reference to B4, external fire spread?
I think the changes that we did make in the draft, we didn't think were significant. As I said last night, they were. We arrived at them probably later in the day than perhaps most of these other bullet points you're looking at here were quite large pieces of work. So there'd been research and cost-benefit analysis, extensive discussions with the working party and other industry stakeholders to try and get the drafts right, and that had taken a number of years to get to that point. Whereas the work that we'd done on external wall construction was something that we'd done much later in the day. As we said yesterday, the primary reason we looked at it was because of the issues that arose from the Edge fire. So that was much later in the day, so it wasn't something that we'd identified as a significant change.
Can we go back briefly to your email to Anthony Bird of the 18th of January 2005? That's at CLG 30188832. We looked at this yesterday in some detail, but if you look at the second paragraph, you can see that in the last sentence, in the second paragraph, you say, however, we do feel it is important that something on this matter, that's the Edge fire, is included within the consultation to ensure that this matter is given due consideration. Due consideration by whom?
Anybody responding to the consultation.
Right. Looking at that, it's clear, isn't it, that you, as the author of this email, were expecting to consult on any proposed change leading from what you had learnt at that point from the Edge fire. Yes?
Yes.
Yes. Why didn't that happen?
I think, as I said yesterday, I think the problem the department had is the point at which the project had got to. It was difficult to insert a new piece of subject matter without falling foul of various government processes which would have delayed the publication of the consultation.
Yes, you did. I just want to explore a bit more with you the process by which that occurred. Would it be right in thinking that you, Sarah Colwell, and Sam Greenwood had concluded that it was important that something about the core of an external panel was consulted on? That seems to be what you're saying in that last sentence.
Yes.
Yes. Did you yourself come to the view after that in fact it wasn't important to consult on it? Or did you remain of the view that it was important to consult on it?
I'm not sure if I can remember what I was thinking at the time, but
Right.
I think we raised it with the department, and it was a matter for the department to decide how it wanted to respond to that.
Right, what I'm really seeking to get at is whether your view changed and you decided, in fact, it wasn't quite as important as you had said here, or whether you were overruled.
My honest answer is I can't remember exactly how the conversation went.
No, but can you remember the gist of what happened? Did you remain of the view that it was important that it be consulted on and were overruled? Or did somebody persuade you that, in fact, it wasn't quite as important as all that and could wait until after the consultation, if ever?
I wish I could remember more detail of this. I appreciate how important it is, but I'm loath to guess what happened.
I'm not asking you to guess. I'm asking you to give us the gist of your recollection. And you did say that it was the department. You raised it with the department, and a matter for the department to decide how it wanted to respond. Who at the department did you raise it with?
Well, it would have been Mr. Bird.
Yes. And did he decide that, notwithstanding your view that it was important to include this question within the consultation, nonetheless, it should not be and wasn't? Did he make that decision?
I don't know whether he consulted with anyone else, but that's my recollection, is that was the decision that was made. Wanted to get the consultation paper to progress, and at the stage it was at, there was a limit to what we were able to do without having to do a lot more preparatory work. So it was decided to wait until after the consultation to look at the question again. Right.
Let's go to your statement, please, which we haven't seen for a while. It's CLG 3019469, page 37, paragraph 110. And you say there, now you're dealing, I should say, with a slightly different matter here in this statement, which we're going to come back to later. This is sometime later on. But I want to look with you at the fifth line down. And if we start in the middle of that line, you say this. My recollection, do you see, it says, my recollection is that the lessons from the fire at the Edge in Manchester had been taken into account when the revisions were made to ADB, leading to the 2006 edition by way of including the word filler in what became paragraph 12.7. I'm unsure why Mr. Greenwood stated that the fire had, quote, signalled the end of rain screen cladding. Rain screen cladding continues to be used to this day. Now, leave aside the last sentence there, which we'll come back to. You refer there to the lessons from the fire at the Edge. What specifically were the lessons from the fire at the Edge?
I guess it's the issue of an insulation material in a location that perhaps hadn't been envisaged in the 2002 edition of the approved document.
And when you say an insulation material, do you mean a material commonly used for insulation purposes?
Yes. So the use of the polystyrene foam in a location perhaps we wouldn't have expected to find it at that point, and the conclusion was that you should be concerned about that, whether it's a ventilated cavity or not, and that you ought to be thinking about similar materials, even if they're not being used as insulation. The issue is the material's fire behaviour, not the fact that it's an insulator.
That's it. The issue is its fire behaviour, not the fact that it's an insulator. Now, that distinction you've just identified, was that one in your mind at the time, in 2005?
I think so, yes.
Right, okay. And when you say here that the lessons from the fire at the Edge in Manchester had been taken into account when the revisions were made to ADB, I think you've accepted that they were taken into account in the final draft, which went to press, but not taken into account in the public consultation exercise.
I think we struck out the ventilated cavity line in the consultation draft.
Was that as a result of the Edge fire?
The
lessons.
I think in general, yes, and the other issues that had arisen from polystyrene that had been used in sandwich panels in other buildings.
Right, but other than the striking out of the reference to ventilated cavities, I think you would accept, given your evidence so far, that the lessons from the Edge fire, so far as finding combustible material in places you might not expect it was concerned, were not taken into account in the consultation process, but only in the final draft.
Yes, I think that's fair.
Yes, thank you. Now, you say here that it was taken into account when the revisions were made to ADB, leading to the 2006 edition, by way of including the word filler in what became paragraph 12.7. Now, by way of including the word filler. Now, when, can you remember, between the date of the fire at the Edge on the 6th of January 2005 and the publication of the revised version of approved document B to press in December 2006, between those dates, had it been decided that the word filler would be the appropriate way to take account of the lessons from the Edge fire?
I can't remember the exact date, but it was after the consultation had closed.
And by whom had that been decided?
I have a vague recollection of a conversation between myself, Mr. Bird, I think some of the other team members at the department. I can't remember if Mr. Green was involved or not.
Who might have been the other team members at the department?
So I think Tracy Cole was one of the team that worked with Mr. Bird.
And what was her expertise?
She was a policy advisor, so not a specialist civil servant, but a policy advisor.
Right. Tracy Cole, yes. Anybody else?
I'm not sure if Darren Hobbs was involved. I can't remember when he...
But he was a policy advisor as well?
Darren was a specialist.
In what?
He's had a background in building control, so similar to Mr. Bird and myself.
Right. Do you know, or can you remember when those discussions took place? I know you say you have a vague recollection.
I can't answer more accurately. I know it was after the consultation, but I can't remember when.
When you had those discussions after the consultation, was your proposed draft text from the 18th of January email discussed? Was it looked at? Or did you have another form of words in front of you?
I don't remember. I remember that I can't even remember who came up with the idea of the word filler. I know it was a word that was used by some of the respondents to the consultation. So
Yes.
what we were looking for was some text which was trying to get people to think more broadly, given that there are a range of different ways that you could construct an external wall. So anything that was very prescriptive and very specific, you'd get the same problem that people might read it in a very prescriptive way and say, well, I'm using polystyrene here or polyethylene or whatever. It's not one of those three words and therefore it doesn't apply to me. Whereas what we wanted the readers to do would be to look at the materials they're using in the wall and think for themselves as to whether or not they felt that might present a risk to fire spread.
You mentioned that yesterday, the idea of getting people to think. Standing back from that as a concept, was it your experience now, after 12 years in building control, that building designers, building control officers, builders would think for themselves using fire safety as the absolute priority? Was that your experience?
My experience from building control would be that what you'd want as a building control officer is some text that you could refer a designer to and say, look, you've not taken account of this. So the idea was it being less prescriptive. It allowed a building control officer to say to a designer, look, this is important. I think in these circumstances you've got a problem here.
Wouldn't it lead to, as you say, more people thinking and more people debating and disputing, greater doubt, rather than isolating and identifying with precision what was allowed and what wasn't allowed by way of guidance?
I think the problem was that we found it very difficult to do that.
Well, I'm going to come to that answer later, but because I'm not sure that it was as difficult as that. But let's see. Before we do, can I just ask you, why was the text that you proposed in your 18th of January email, which simply deleted the reference to ventilated cavities but said other material, not used in the final version? That would have done the trick, wouldn't it?
I think, as I said in the email, I think the problem for the department would be that it probably went too far. That the challenge is, in a generic way, trying to identify those things that are a risk and those things that aren't. that was something that we struggled to do.
Well, the risk was simply combustible core of an external wall panel. Why not say that the core of an external wall panel should be a material of limited combustibility in the same way as insulation?
Well, that addresses that problem, but not all the other potential places that someone might use a combustible material in a modern wall.
But you weren't addressing that. You were addressing a specific problem at the edge, which was that somebody had put a combustible core inside an external wall panel.
I think the problem we were trying to address is that an overly prescriptive piece of guidance would allow a designer to ignore what might otherwise be an obvious risk.
So what else were you seeking to require to be a material of limited combustibility?
To some extent, the things we hadn't thought of, that was the point we were trying to address, is that there are a lot... The construction of external walls was becoming much more complex, and there were lots of different approaches that were cropping up. We wanted something which wasn't tied to a particular form of construction, because that to some extent has been the problem in the past.
So you were trying to go further than the edge fire, but not as far as everything, and picking some kind of vague ground in the middle.
Yes, that's where we landed, yes.
Right. Let's look at the source then of the word filler. Having now, I think, established where you landed, let's see how you approach the landing. I think we can start with this, with Anthony Bird's statement, CLG 3019461. And I'll put this on the screen, page 12. Where he addresses this in 3 paragraphs, 29 to 31, and he's given evidence about this, so I think I can summarise it. And in summary, he says that it was Nhbc who raised the matter in the consultation, that's paragraph 29, and we'll come to the response in a moment. You can see that he quotes from it there. Paragraph 30, he says that the BRE had reported in the investigation of real fires on the edge fire and used the word filler there, as we saw yesterday, and then he had consulted with you, and that's paragraph 31 over the page, after which the addition was made. Now, I've given you a very broad summary of his recollection. Does that accord with your recollection?
Yes.
Yes. Now, let's then look at the NHBC's consultation response. It's at CLG 402410. CLG 402410, and you can see that it says response form for the consultation on proposals for amending ADB, and then in the right-hand side of the box, please return by 18th November 2005 to Part B review at the BRE. Now, we know that the metadata tells us that it's dated the 8th of November 2005. Take that from me, it's not clear from the screen. And if we go, please, to page 24, under paragraph 24, under any other issues, it says this. Clause 11.8, clarification is required within clause 11.8 as to whether insulation material includes sandwich panel core material. Whilst the removal of reference to ventilated cavities is helpful, currently there is confusion as to whether metal cladding panels that use polystyrene as a filler can be used on buildings over 18 metres in height. Typically, these panels are faced both sides with aluminium, and as such may be considered by designers to be non-combustible. Now, do you remember reading that consultation response at the time it was received? So early to mid-November 2005.
I don't remember it, but I must have seen it.
And presumably it was part of your role under the contract with the department to read and analyse these responses?
Yes, Mr. Greenwood and myself went through all of the responses.
Right. Now two things about this. Do you agree that it suggests that not only was there confusion about whether these sorts of sandwich panels were permissible, but also that there was a belief held by designers that metal-faced cladding was non-combustible? You see that?
It suggests them that it may be considered by designers.
Yes. Now, the inclusion of the word filler doesn't resolve, does it, or didn't resolve, the problem of manufacturers and designers not understanding what type of cladding panels were permissible, does it?
Well, at the time, we thought it was the best guidance we could give.
But the word filler doesn't answer the problem about what type of cladding panels can we use. Do you accept that?
Well, it doesn't give you a list of which products you can or can't use.
Well, it doesn't refer to panels at all, does it? The word filler doesn't connote panels, does it?
I think at the time we were thinking of products such as the core of a sandwich panel.
Yes. Was there a risk here that, in fact, as has eventuated, that designers and manufacturers, builders and others might regard the cladding panel itself as being judged solely on its outer face and not by reference to its core?
I think that was the risk that we were trying to address.
Well, why not use the word core?
I don't know. We sat in a room, decided, came up with some words that we thought would be correct and used them. Core material is something that's used fairly regularly. I'm not sure if it was at the time, and I think we'd seen these responses and thought that filler was a more generic term.
Well, whose idea was it, first of all, to use the word filler?
I can't remember.
Where did the word come from? You say it's a more generic term. Explain. What do you mean?
I mean, arguably, they both could mean the same or something else.
Well, yes. And was that thought you've just articulated something that went through your head at the time you decided to pick the word? It could mean that. It could mean something else.
As I say, we were trying to come up with something which was broader to try and generate that kind of conversation between the building control body and the designer so that they thought these things through.
But why would you want to do that? Why would the department who was responsible for ADB providing guidance to the industry want to provoke conversations? What's the point of conversations?
I suppose that's how a functional system of building regulations work, is the designer and the building control body decide what they think meets the functional requirement.
By reference, in part, to the approved document which gives guidance, yes?
Yes, in part.
Yes. So why would you want to have a conversation about the guidance as opposed to clear guidance, which might provoke a conversation about the functional requirement?
I think at the time we didn't think we could come up with some some text that was as specific as that wouldn't then result in something that was too narrow, and we'd end up with some other form of construction that would create the same problems.
What was the risk of coming up with some other kind of construction which would cause the same problem if you'd simply picked the word core and said the core of an external panel shall be material of a limited combustibility? That would be crystal clear, and you wouldn't need some conversation.
If you were thinking about all you were thinking about was the core of a external panel, but we were concerned that there were a lot of different forms of construction that were emerging, and so we tried to use something more generic.
Well, what other form of construction were you reaching for with the word filler that would cover not only the core of a rain screen panel, but some other element of the external wall build-up?
Could have been some of the sheet materials that are used that provide stiffness to the steel frame of an infill type construction.
Well, you say it could have been. Was that a thought at the time? The sheet materials that are used to provide stiffness to the steel frame?
I can't remember exactly what was going through our minds at the time, but at that time we thought this was the best we could do.
And what the edge fire being the catalyst for this problem, what else at the edge led you to think that you needed to go broader than the polystyrene core of an external wall panel, such as, for example, some of the sheeting materials used to provide stiffness in the steel frame of an infill construction? What was it about the edge that pushed you wider?
I think we were trying to avoid picking on specific products because you tend to find that makes people not think about what they're doing.
Well, there are only two specific products, you call them products, two specific elements of the external wall construction, apart from cavity barriers, leave that on one side, that are regulated at all. There's the insulation and there's the external wall surface, yes? What became 12.7.
But what's regulated is the fire performance of the wall, and modern walls were becoming progressively more complex.
Right, so in addition to the insulation and in addition to the core of a rain screen panel, call it that, what other element of the external wall build-up were you seeking to cover with the word filler?
So to some extent we were trying to cover things that we weren't aware of, that we thought that could emerge, and as I say, our experience was that where in the past people had been very prescriptive in their guidance, that's where the risk of people would just read it pedantically and say, I've got a material which isn't one of those three words, therefore doesn't apply to me. And at that time, we were thinking that it would be better to try and get the designers and building control bodies to think about the issue more broadly. That's how the structure of that section was designed to work.
As it were, then, for them to work out themselves, to fill in filler. In other words, to take this broad portmanteau expression and just work out for themselves what fell within it. Was that the idea?
Yes, I think to some extent that's what we were trying to do, yes.
Right. Did you discuss the meaning of the word filler with Anthony Bird before it was inserted into the text?
I think there were 3 or 4 of us that sat down and talked this through, tried to decide what we could do to improve on the text that we'd consulted on, respond to the comments that we'd received, and try and address the problem as best we could.
Do you recall whether it was you who spotted the word filler in the Nhbc response and said, let's use that, and Anthony Bird agreed, or was it Anthony Bird who spotted the word filler and you agreed?
I don't remember. It's a word that emerged in the conversation.
Right. Anthony Bird recalls it, that it was you who approached him saying that you hadn't suitably covered off the filler situation from the Nhbc and the edge. And his recollection, and I use that word in the context of the evidence he actually gave, is that it was you, or probably you, who approached him with that word. Can you recall that?
I don't remember. It could have been.
Do you remember discussing the word with the BRE and asked them whether they'd come across it in common parlance or whether it had a technical overlay or something like that?
Not that I recall.
Is it a word you'd come across in any technical application yourself before it was inserted?
I don't think so, no.
Did you discuss the word filler at any stage with Nhbc?
No.
Did you discuss it with anybody outside the department?
Not while we were drafting it, no.
At all, ever? After you drafted it?
Years later, when the question arose.
Oh, indeed.
But not between the conversation where we came up with this draft and the publication of the approved document.
No, thank you. Do you remember when the word came to be inserted into the text of approved document B?
Sometime after the consultation. Again, I think it was later on, but I'm not sure.
Yeah, no, you're right, and I just wanted to test your memory to see if you could remember. Now, let's go through. We've seen the BRE's investigation in the FOSI, the Fires of Special Interest report. We've seen the NHB's consultation response of November 2005. Let's jump then a year later to CLG 1302082. What I'm showing you here is draft version 15 of the new edition of ADB, and you can see that from the words at the very top right-hand corner, draft 22nd November 06, 2006/15. Can you see that?
Yes.
Yes, and it says B, as you can see. Now, if we go please to page 129 in this document, we can see that here is the relevant text of what is now, and then became, 12.7. Now, this is the new text. It's the same. When you look at 12.7, it's the same, isn't it, apart from the changes to the references, as the 2005 consultation version?
Yes.
Yes. I'll read it aloud. It's insulation materials, that's the heading, and the text says, in a building with a story 18 metres or more above ground level, any insulation material used in the external wall construction should be of limited combustibility, see Appendix A. Yes?
Yes.
And there's no reference there to filler. So that's where you are in November, and the heading of 12.7 is insulation materials. Now, if you look above that to 12.5, you can see that the final part of the sentence referring to 12.6 to 12.9, and I'm sorry, the final sentence that had referred to diagram 40 has gone, and it now simply ends by saying may be present or may present such a risk in tall buildings. Do you see?
Yes.
And we can see, let's compare that with the consultation version, CLG 6022, page 147. That's the consultation version we saw yesterday, and you can see the second sentence at 11.6, which ends, may present such a risk in tall buildings, even though the provisions for external surfaces in diagram 40, now 30, may have been satisfied. Now, do you see it was there, but when we go back, please, to the document we were just looking at, draft 15, CLG 1000282, page 129, if we just have that on the screen at the same, oh, doesn't matter, it's gone. You can see that that second part of the sentence, referring to diagram 40, has disappeared.
Yes.
Yes. Do you know why that caveat that had been in the previous version of ADB and the consultation version as sent out was removed?
As I remember it, because we'd restructured the order of these paragraphs so that it was a section talking about external wall construction, the intention is that you would read 12.5, 12.6, 12.7, 12.8 and 12.9 as a collective discussion about the construction of an external wall. And therefore that caveat was no longer necessary because it was saying you need to do all of this stuff to satisfy the requirement B4.
So it was a deliberate decision, was it, to remove that caveat?
I think so. I think we decided that the caveat wasn't necessary because whereas the old guidance had it split external surfaces and construction in a different way, we felt by having a section that talked about external wall construction, it addressed all of the issues associated with external wall construction in one place, so there didn't need to be that caveat anymore. That's what I remember.
Whose idea was it to remove that caveat? Was it yours? Was it Anthony Bird's? Was it anybody else's?
I suspect it was mine. I'm not sure, but I think so.
What consideration did you give to the effect of the removal of that express warning that the use of combustible materials might present a risk notwithstanding compliance with diagram 40?
I think I took the view that the second paragraph of 12.5, where it says look at all of the guidance, was doing the same job.
But it isn't, is it? It's the one thing it's not doing, to the extent that it did before, it's certainly now not doing, is telling the reader that even though you can pick up a panel and have it comply with diagram 40 and 12.6, nonetheless you might not meet the functional requirement for the given building, given its height, use and position. It's gone. Yes?
Yes.
And therefore, somebody reading the guidance might think that if they've met the guidance in 12.6 and diagram 40, they had at least presumptively met the functional requirement as well. The warning that they might not have done has gone. Yes? Did you think about that?
Not at the time, no.
Why is that?
I think at the time we took the view that the introduction in 12.5, which says the use of combustible materials in the cladding system may present a risk, and that second paragraph that makes it clear that you need to address external surfaces and the subsequent layers needed to be considered.
But the first part of 12.5 has two sentences. The first is a very general warning or piece of guidance. External envelope should not provide a medium for fire spread if it's likely to be a risk to health and safety. That's a statement of the obvious, isn't it?
Yeah, I suppose so, yes.
Yeah, it is. And looking at the second sentence, the use of combustible materials in the cladding system and extensive cavities may present such a risk in tall buildings. Well, that's also a statement of the obvious, isn't it?
I suppose.
Yes. And what's critically missing here, isn't it, is the caveat that even though you're using materials or products which meet the guidance, nonetheless you might not meet the functional requirement given this particular building, its height, use and position.
Yes, I think at the time we thought that, whether it was we or myself, I'm not sure, but I came to the conclusion that that line wasn't necessary anymore because of the way that we'd structured the guidance, referring people to say you need to look at all of it, and therefore it was an unnecessary sentence. I think in hindsight I wish we'd left it in.
Did you go to BRAC with that amendment, the decision to delete the caveat, which we see in the second part of the second sentence of the old 13.7 and in draft in the consultation 11.6?
I don't think we raised it with them specifically. We may well have circulated a late draft with them, which would have shown where the various edits had taken place, but it's a very large document, so they may not have picked it up.
And you don't recall them picking it up with you? And
no, I don't remember a conversation with BRAC on that subject.
No. And did you don't have to tell me what the content was if you did, but did you think to take legal advice on that amendment?
A draft-approved document is always reviewed by the department's lawyers, but I don't think we would have specifically pointed them at this particular change.
At what stage did the department's lawyers review the final draft before it went to press? Or did they? That was a prior question. Did the department's lawyers review the final version of ADB in draft before it went to press?
I don't know for sure, but they have done on every other draft-approved document I've ever worked on, so I assume they would have done on this.
Right, but did you draw this change specifically to their attention?
I wouldn't have done that. Would have been a conversation between Mr. Bird and the department's lawyers, right. I think.
Do you know for a fact whether that conversation took place, or are you just speculating? I
can't say that for a fact.
Now, let's go then next, please, to CLG 1000270. We've looked at various drafts disclosed to us, and all the versions we've identified up to the 22nd of November contain the same wording. Now what I'm showing you is a one-page document here, which is the relevant part of Section 12. And this was modified, take this from me, this was last modified on the 22nd of November 2006. In other words, the same date as version 15 we were just looking at. And if we look at 12.7 here, we can see a number of things. First, we can see the introduction of the words filler material, etc. Do you see? In any insulation, filler material, etc., used in the external wall construction should be of limited combustibility.
Yes.
So that's gone in, yes? And we can also see the heading has changed. It's now insulation materials stroke products, whereas before, same day before, it was insulation materials with no stroke products after it. Yes?
Yes.
So those are the main changes. Now, in fact, the changes. Now, the document properties, take this from me, show the author as Martin. Now, I'm assuming that's you.
Yes.
Did you draft this document?
I must have done.
Right. Now, how did you come to insert the word filler for the first time on this date?
It would have been following the conversation I'd had with Mr. Bird and his colleagues.
Right. And it says it's not just filler, it's the phrase, filler material, etc. Was that a phrase that you and Mr. Bird had agreed before you typed it in?
I believe so, yes.
Right. And again, can we take it that there were no discussions that you had about that phrase outside the department? BRE, BRAC, anybody else? That's
right. I think the timing was such that this wasn't given the same extensive considerations as to what at the time we considered to be the big policy changes, which were those listed in the consultation draft.
And going to the heading, you can see the addition of the word / products in the heading there. Did you discuss that with Anthony Bird too?
I think we discussed all of it at the same time.
Right. So again, a bit like filler material, etc., the / products went in as an agreed form of words that you had discussed with Anthony Bird before you typed it in. Is that right?
Yes.
I see. Now, what was your purpose in adding the phrase / products after insulation materials?
As I say, from memory, what we were trying to do was to get people to think beyond just looking at the term insulation when there could be other combustible materials being introduced into the wall construction.
What did you think people would understand by the phrase insulation materials / products, as opposed to insulation materials?
I mean, I can't remember exactly what was going through our minds at the time, other than to say that was our objective was to try and broaden the target that this paragraph was addressing.
Well, why did you put the phrase filler material, etc., under the heading insulation materials / products? If you were trying to broaden the target that this paragraph was addressing.
I think at the time we thought that putting / products in there would show that it was going beyond just insulation materials.
But not further than insulation products?
Having spoken to lots of people about how they read this paragraph at various points over the years, it's clear that can be read in two different ways. At the time, I think we thought it was doing the right thing.
But doesn't that just demonstrate the dangers of not consulting on even a small change in language in the guidance?
Yes, and I think it's something we would have rather avoided. But the nature of the timing and how it fitted with the rest of the project meant that we came to this issue too late in the day.
If you intended the text of 12.7 to apply to materials, any materials or products other than insulation, why did you put it under a paragraph headed insulation materials / products?
I wish I could remember what was exactly in our minds at the time, other than that general statement that we were trying to be more broader. Looking back at it, I wish we'd been able to spend more time on it and talk to more people.
Right. I mean, did you intend to slip this in under the radar at the last minute and hope people wouldn't notice?
I think there was a problem for the department in that the further we extended this, the less it would have aligned with what had been cleared through the sort of policy process.
Well, why does that matter? Why not just have a standalone paragraph that dealt with the core of an external panel with a heading to match, send it out unconsulted on, but with very clear industry information about what precisely it is intended to apply to, and make up for the absence of consultation that way?
I think at the time we thought this was the right thing to do within the constraints that Mr. Bird and the team were working in.
And I think you accept that this phraseology and heading had at least the obvious potential to be understood as applying only to insulation.
I didn't think that at the time. It's something I recognised later on.
And there's nothing in there that would lead a reader to conclude that this particular wording is to apply to anything other than insulation, whether it's a material or a product.
I think the final text includes the phrase not including gaskets and sealants.
Yes, we'll come to that. It does. But just taking it in stages, before we get to that, do you accept what I'm saying, that there's nothing in there to lead a reader to conclude that this particular wording, at this stage in the drafting, was to apply to anything other than insulation, whether a material or a product?
The fact that it says any insulation product, filler material act, so it implies that a filler material isn't an insulation product.
So why put it in under insulation materials / products as a heading?
I think because we thought that the / products meant things that weren't insulation.
How could you possibly have thought that?
That's what we thought at the time.
What, so insulation materials and all other products in the external wall, is that what you meant?
I think so, yes. We were trying to, as I say, we were trying to get people to consider all the various components that they might include in a wall. Modern walls are quite complex. There are lots of different components in them.
Well, there are two components, aren't there, which matter?
No, definitely not. There are lots of different components that matter.
Just let me finish my question.
Sorry.
There are two components that matter, which are picked up specifically here, if you ignore cavity barriers. One is the external surfaces, and the other is the insulation. So where else in the external wall build-up were you aiming by tacking the word / products onto the end of insulation materials?
So those things that could have been included in the wall that weren't insulation. So, for instance, the core material of a sandwich panel in the case of the edge, vapour barriers that get included in cavity sometimes, and the sheet material that gets used to stiffen some types of wall construction. When you get to a timber frame building, again, you get other bits of component in there. That's what we were trying to do. It's evident that it didn't work. So I can see why anyone looking at me now thinks, what were you doing? But at the time, that's what we were trying to do.
But wasn't the simpler approach simply to have a new paragraph which was perhaps headed core of external panels and required those to be of limited combustibility? What was the problem with doing that?
It was something I think there was a concern that by identifying a specific product in a very prescriptive way, that might fall foul of having not consulted specifically on that, and that there's a risk of manufacturers challenging the department, and you find yourself dealing with the judicial review.
Right. So this was really more about keeping it sotto voce, keeping it under the radar, making a change, but sufficiently quietly that people wouldn't make a fuss about it.
I wouldn't say that's more of it, but I think there was a component of that in the thinking, yes. Our main thinking was trying to come up with something that was broad in its impact.
Some might say vague.
Some might say vague, but what we were thinking was broad.
Can we then go to CLG 1002196? You referred to gaskets, sealants and similar a moment ago, and I just want to have a look at that, please, next. Now, this is an email run in December 2006, and if you go down, please, to the email on page 2, well, I think it's foot of page 1 is where we want to go, right at the foot. There's an email from Steve Bergner, who Anthony Bird described as the intelligent client. I think he was responsible for taking this to press. But you tell me if that's wrong.
That sounds right.
Right. Now, it goes to Tempo at GDL and John Saunders, copy to Anthony Bird and others, not you. And the subject is read first thing on Monday 18th, please, ADB. Hi. And then if we turn the page, please, to page 2, in the second paragraph, he says this. The changes made to this document on Friday were minimal, so this should be straightforward. The client, however, wants a last check. Rather more changes were made to Volume 1. We've received this safely. Thanks. Now, did you make any last-minute changes to ADB, Section 12, on the eve of it going to press at this time?
It's possible, I don't remember.
Right. Now, the version approved by Anthony Bird for publication on the 18th of December 2006, we can find at CLG 100002200, please. And if you go to page 96 in that, we can see the formulation of 12.7, which we're now, I think, familiar with. And it says, insulation materials, stroke products, 12.7, in a building with a story 18 metres or more above ground level, any insulation product, filler material, not including gaskets, sealants, and similar, close brackets, etc., used in the external wall construction should be of limited combustibility, see Appendix A. Now, was the phrase in brackets, not including gaskets, sealants, and similar, etc., added by you on the Friday before publication?
I don't know.
How else did it get in there?
Mr. Bird might have added it, or one of his team.
Do you, can you be sure, or as sure as you can, that you didn't add it?
I can't be sure.
Did any discussions take place between you and Anthony Bird after the 22nd of November 2006, but before the 18th of December 2006, about further modifications to the draft paragraph that you sent, which didn't include the words in brackets?
I would have thought that if Mr. Bird or someone in his team had suggested a change at that stage, that we would have discussed it as a group.
Right. You don't recall very last-minute additions of this qualifier yourself?
Not this particular paragraph, no.
The difficulty we have is that we have absolutely no documentary record from the department on this, so we are entirely reliant on your and Mr. Bird's recollection, you'll appreciate. Do you remember thinking or having thoughts or discussions about the need to reduce the scope of the expression filler material, etc.?
I don't remember.
Do you remember thinking about gaskets?
I don't remember thinking. I can see why you would include, if on the grounds that you're thinking this is applying in a much broader way, you'd be concerned that you wouldn't want to prohibit the use of rubber gaskets and silicone sealants and so on, because there isn't really a material. There isn't an alternative that's a material of limited combustibility. So I can see why someone would have said perhaps we need to put this additional information in there so that we don't prohibit people using sort of waterproofing products.
Did you yourself think or have any discussion about the relationship between the concept of filler material and the concept of gaskets or sealants or what was similar to those things?
I don't remember.
Did anybody, did you think that by expressly excluding gaskets, sealants and similar, that might have an impact on how people read the words filler material?
I don't remember. I mean, I think you don't have gaskets and sealants in insulation products, so I think it confirms that this is intended to apply beyond insulation.
Nor do you have gaskets, sealants and similar in the core of an external rain screen panel.
You'd have them around the perimeter of them sometimes.
Well, yes, maybe, but not in them. So the edge problem, the polystyrene filler in the sandwich, so to speak, wouldn't be addressed by excluding or clarified by excluding gaskets and sealants, would it? think about that?
I think I'm guessing, but you could well have a sandwich panel system which is sealed at its joints with gaskets, and whilst you'd want the designers to address the core material of the panel and the surfaces of the panel, you'd have to accept that there might be a rubber or silicone gasket.
But let me try this slightly differently. It may be my fault for not putting the question with greater precision. Do you accept, or did you think at the time, that by specifically excluding excluding gaskets, sealants, and similar, people who read the phrase filler material might think, well, whatever else it applies to, it doesn't apply to the core of a composite external rain screen panel, because they don't have gaskets or sealants and similar in them?
I certainly didn't think of it at the time, and I'm not sure I accept it now.
Did you discuss with Anthony Bird, coming back to the word filler, what that word might mean to industry?
We would have discussed it when we came up with that form of words.
Did you, when coming up with that form of words, think that there was an accepted and settled industry understanding of the term filler or the phrase filler material?
I can't remember the detail of the conversation there.
Did you suggest to Anthony Bird, or did Anthony Bird suggest to you, that the department should ask industry whether that term would readily be understood as applying to the core of a composite metal panel?
That's not something we thought of at the time. I think, to put this in context, this is one paragraph in a large document. We'd changed nearly every paragraph, so this was a big project. And whilst clearly now it's a fundamental issue, at the time it was one of hundreds of paragraphs that we'd amended.
I mean, did you ever consider that the word filler might in fact suggest some kind of product used to fill or block existing gaps or voids, such as expanding foam filler? We have some here. Polyfiller. Did anyone think, well, filler could be thought of as that?
I don't think we thought that at the time, no.
And as Mr. Bird said, a filler is there to fill a void, as it does, as we can see. Did anybody think at the time that, in fact, an external wall panel doesn't have a void? It's a composite product made by bonding a piece of polyethylene or polystyrene, as the case may be, to two sheets of metal, aluminium or other.
I think at the time we thought it was a good generic term to describe those things that you inserted inside a construction.
But that's the point, isn't it? If you're aiming at the edge, the polystyrene doesn't get inserted, does it? It gets made at the same time. It's a composite product, which is made by bonding a piece of polystyrene, in that case, ACM, PE, to two sheets of metal. That's why it's a composite product.
So at the time we thought that was the right term.
Did you take any steps to make sure, you being you and the department, that the word filler was generally understood in the sense in which you intended it before you introduced it into the final text?
No.
And is that because you wanted to get this through without making a fuss or without provoking a JR challenge? Because it hadn't been consulted on?
I think it was because we had limited time available at that point.
Do you know why the word filler wasn't defined in the approved document when it was introduced?
I think because we were trying to use generic text, we didn't want the problem with producing definitions of terms is that you then find everybody argues about what the words in the definition mean. So if you're trying to get people to think broadly, then a definition can be counterproductive.
Taking it in stages, Appendix E was available to you as a definition section, wasn't it?
Yes.
And it had plenty of definitions in there, didn't it?
Yes.
And did you deliberately not define the word filler? Was that a deliberate decision?
I'm not sure it was. I think we wanted to use the term in its sort of natural sense, so we didn't at that time we didn't conclude that a definition was necessary.
Right. Now let's just break that up. Was your thinking that the word filler was so clear to everybody and everybody would understand it your way that there was no need to define it? Or was it your thinking that you didn't want it defined because you wanted people to have a conversation about what it might mean?
I don't think we considered it quite as precisely as that, but the latter is close to what was in our minds at the time.
Right. And it ever occurred to you that the absence of a definition might make the term unclear or ambiguous? At least in the absence of any clear evidence of a settled industry understanding?
Not at the time, no.
And I think you accept that none of this was put before BRAC and not consulted on before it was sent out.
That's correct.
Now let's go to your statement, please. CLG 30194669, page 6, paragraph 18. You say there, given the need to consult BRAC and other representative persons on substantive changes to the regulations, it would be highly unusual to make quick changes to either the approved documents or the regulations. Any substantive change would have to be assessed against government regulatory policy of the day, discussed with the main BRAC group and potentially a BRAC working group established specifically to consider the proposed change, subjected to public consultation, and then scrutinised by ministers and sometimes by Parliament. Now, can we agree, Mr. Martin, that in relation to the specific wording added to paragraph 12.7 on and after the 22nd of November 2006, but before going to press on the 18th of December 2006, not one of those steps was taken?
I think what we were doing was reacting to some extent to a response we got to the public consultation. It's nature. If you put out a consultation draft, people respond to it, you amend the text accordingly. So in that respect, we were responding to comments that had been made to the consultation.
But that can't be right, with great respect, because you didn't actually ask people or put before them the edge problem and ask them how they thought it should be solved. So it wasn't a consultation, was it? It was a single word and a single response from the Nhbc as a result of they having picked up on the incident.
Yeah, we were responding to the comment that they had made.
It was a comment that they had made voluntarily, but not something you would ask the entire consultation body about. That's my point.
That's right, which I think is probably why we were constrained about how far we could go in response to it.
And at the Nhbc were certainly not suggesting to you how you should encapsulate the problem in the wording of the approved document, were they?
No.
No. And given that you didn't ask the Nhbc about what they meant by filler, but just adopted it, it's not right to say, is it, that the consultation response or the consultation itself covered this issue? It didn't, for the reasons you've given.
Well, the consultation asked people to comment on the entire draft. That was one of the responses we got from the Nhbc.
Can we agree that the only scrutiny, your word, to which the particular changes to 12.7 received was yours and Anthony Bird's, and perhaps your colleagues in the department?
Yes.
Was there any discussion between you and Anthony Bird at the time about all the steps in the normal process, and specifically the fact that none of them had been taken in relation to this change?
I think across the board, it's the nature of the way these documents are drafted. You produce your draft for consultation over, in this case, several years of work. As the document finally comes together, there's a process of refinement, and so small changes like this would have been made across the entire draft.
Now, I'm going to ask you a question which you may have answered already a number of times, but I just want to be clear if I can. When 12.7 went to press, what did you intend the wording in that final version to mean by reference to slash products and the reference to filler material, not including brackets, etc.?
The intention, as I understood it, was that it was to be, it was intended to be a broad comment about certainly insulation materials, but also other materials that might be found inside a wall construction that could have a potential to result in an external fire spread that requirement B4 was trying to prevent.
Right. Were you seeking to exclude all elements of an external wall arrangement?
No.
So you weren't, to be clear, you weren't seeking to require all elements of the external wall build-up to be material of limited combustibility?
That's correct.
And other than gaskets and sealants and similar, what were you seeking to exclude from the requirement of materials of limited combustibility?
The structural frame, so a timber frame building, for instance.
Right. So was it your intention that everything in the external wall build-up, other than the frame, should be of limited combustibility?
In general terms, yes, but it's quite difficult to define where those things start and finish, which is the problem that we had.
Why not at least say so? Why not at least say everything except the frame in an external wall build-up must be of limited combustibility? That would have solved it, if that's what you were seeking to achieve. No?
Only that it's quite difficult to define where the structural frame starts and finishes.
Why is that?
Depends on the form of construction you're using. Sometimes it's not quite obvious where they do start and finish.
And was that the problem with the breadth of the draft that you'd originally attached to your 18th of January 2005 email?
Yes.
But what was the problem in excluding frame and defining frame? What's the problem with frame that you'd come across that meant that identifying a clear exclusion from the general rule that everything in the external wall build-up would be of limited combustibility was difficult?
There are so many different ways of constructing a building. Trying to define those different elements in a prescriptive way just create a similar problem to the one that we envisaged with the edge, which is that whilst most people would recognise the polystyrene as an insulation material, in that particular form of construction it wasn't an insulation material. So that kind of very prescriptive approach to describing all the different components of the building we didn't think would work.
And was that a thought process you had at the time?
I think so, yes.
Did you intend and understand the scope of the new language with its new breadth of 12.7 to extend to the external surfaces of cladding panels as well as to the core of those panels?
That was not the way I read it.
Right, so in answer to my question a moment ago, whether you were intending, leaving aside frames, that all elements of the external wall build-up should be of limited combustibility, you missed one out, I think.
Yes, I think that's fair.
Well, why didn't you mention it just a minute ago?
I'm sitting here with no notes answering questions that I'm not expecting, so
All right.
I may not always answer your questions precisely.
Okay, so I just want to see if we can identify with some precision your thinking at the time. you have all elements to be material of limited combustibility, but not the frame, but also not the external surface. Yes?
I think that's fair, yes.
Well, it may be fair, but was it your thinking at the time? I want to get into your head in the back part of 2006.
That's what I believe I was thinking at the time, yes.
Right. Now, you thought it didn't extend to that. I see. Did it occur to you that if the insertion of the word filler material, etc., in 12.7 was to tell the reader that all elements of the external wall build-up were to be of limited combustibility, then you needed to amend diagram 40, perhaps to delete it altogether?
If that's what we were setting out to do, we would have done, but that wasn't what we were setting out to do.
So was the idea, therefore, that because you weren't intending to extend the requirement of materials of limited combustibility to the external surface, you preserved diagram 40 and 12.6?
I think that's what we were thinking at the time, yes.
Did you at some later point come to the view that the external surfaces of the cladding panels, rather than only the core of a cladding panel, were caught by 12.7 and should be of limited combustibility?
It's not something I've ever considered, I don't think.
It's not something you've ever considered. Right. Mr. Chairman, is that a convenient moment?
Yes, I think it is. Thank you very much, Mr. Millett. Right, well, Mr. Martin, it's time we had a break for the morning. We'll stop now. We'll resume, please, at 25 to 12. And as before, please don't talk to anyone about your evidence or anything relating to it while you're out of the room. All right?
Yes, sir.
Thank you very much. Would you go with the usher, please? Thank you very much, Mr. Millett. 25 to 12, then, please.
Thank you, Mr. Chairman.
Welcome back. Mr. Millett, if you're ready to continue, perhaps you'd ask the usher to bring Mr. Martin back in, please.
Yes, thank you, Mr. Chairman. May we please have Mr. Martin back into the hearing room?
Good. Hello again, Mr. Martin. You ready to carry on, I hope?
Yes, sir.
Thank you very much. Yes, Mr. Millett.
Yes. Mr. Martin, can we now go, please, much further forward in time to the summer of 2013? I want to take a trip there, if we can. CLG 3019219. Now, what I'm going to show you is a series of emails from that time between you and a gentleman called Daniel Turner, who I think was a building control officer at Ipswich Borough Council. And you can see here the first two emails in the chain, or the last two emails in the chain. I'm not going to go through every single one of these emails. Can we please go to the one he sends you, second down, on the 14th of June, there, at 10:25 in the morning. Yes? And he says, the subject is external walls in high-rise buildings, and he says, Martin, I think he thinks is your first name, perhaps, I don't know. I trust you're keeping well. You may remember several months ago you provided some guidance on the use of combustible insulation via SIPS panels within the external wall of a building over 18 metres high in respect of paragraph 12.7 of ADB Volume 2. Following our discussion and some further research, excuse me, the architect amended their design to include a metal framing system and also incorporated an insulation board which had been tested in accordance with BS 8414 Part 1 2002. And then he goes on to explain the changes made to the specification. And if we go on to the third paragraph down, he says this: my query is, the guidance given within paragraph 12.7 refers specifically to the insulation material being of limited combustibility, but does not refer to the substrate that it is fixed to, etc. If the sheeting boards were a sheet of plywood, would this meet with the spirit of the regulation's intention, or should these be of limited combustibility also? If ply were acceptable, the cavity would obviously need to be subdivided at a maximum of 10 metre centres to limit the spread, I think he means there, of a fire within this void. But as noted above, we are unsure as to whether a ply sheet is acceptable in the first place in this instance. Are you able to offer any guidance on the intention of this paragraph of the approved document? Now, by June 2013, you were an official full-time at the department with responsibility for approved document B, weren't you?
Amongst other things, yes.
Yes, amongst other things. So do you accept that you were the right person for Mr. Turner to go to for guidance on the intention underlying this provision of ADB?
Yes.
Yes. Now, moving up to the chain, up the chain to the top email, you respond the same day, a little bit later, and you say this: hi, Daniel. The AD doesn't preclude the use of timber sheathing, as this would effectively outlaw timber frame construction, and the evidence didn't support this. However, the cavity barriers would need to be would be needed in line with all compartment floors and walls in order to meet the guidance in the AD. BR report, what BR 135 may help with some of the issues. Now, first, your response to Mr. Turner was, would you accept this, clear and unequivocal advice? Yes?
Yes.
Yes. Now, when you say the evidence didn't support this at the end of the first sentence, what evidence were you referring there to?
I'm not sure I remember what particularly I'm thinking of there, but certainly the department hadn't chosen to prohibit the use of high-rise timber frame construction.
Well, what evidence did you have in 2005 or 2006 before the amendment to ADB which might have supported or not supported a restriction on the use of timber above 18 metres?
It's probably the work that went into the Timber Frame 2000 project that
Right.
I mentioned yesterday.
I see. So when you use the expression the evidence didn't support this, were you referring to evidence that you had or the absence of any evidence to the contrary?
Probably evidence that I was aware of from the Timber Frame 2000 project.
Right. And to be precise, what was precluded by that evidence?
Well, say the Timber Frame 2000 project was about working out coming up with design advice on how to construct high-rise timber frame buildings. So it didn't. It's quite a complex document, lots of different issues in there.
Right. Here we have a reference to timber sheathing. Clearly, you're saying that was permitted and not precluded by 12.7. What's the difference between timber sheathing and timber frame construction? How does timber sheathing relate to timber frame construction?
So, for the most common form of timber frame construction, a framework is constructed with timber, vertical and horizontal timber members, and to provide stiffness to the frame, usually a timber sheathing board is fixed to that structure.
Right, so timber sheathing you understood to be part of timber frame construction on the basis of this report that you had in mind at the time?
I think so, yes.
Right. We'll come back to Mr. Turner at a later stage. Can we go please to CLG 15038? This is, as you can see from page 1, a circular issued by the department, and you can see from the top right-hand corner that it's dated the 18th of December 2006, and the subject is the amendments to Part B and other things, yes?
Yes.
Did you play any part in drafting this document?
I think I did, yes.
You think you did? And what part did you play?
I would have been one of a number of people that worked on the text.
I see. And did you understand that the purpose of the circular was to notify as wide an audience as possible of the impending changes to, among other things here, the amendments to Part B?
I think it's primarily aimed at building control bodies.
Why do you say that?
I think it's the nature of what the circulars were for.
Right. How were they circularised? What was the mechanics by which they were circularised?
I think at that time, I think the department had arrangements with. It was either the replacement to Her Majesty's Stationery Office, which used to provide a range of publication and printing and distribution services. So it was either that organisation, which I think became at least part privatised at some point, or it may have been a contract with an entirely separate contractor. But I think at that time these would have been posted en masse to a standard list.
Right, a standard list. And would the standard list only include building control bodies or groups, such as the BCA or an Nhbc, or did it include others, other representatives of the industry, such as, for example, the CWCT?
I think this probably would have been circulated only to all the local authorities and registered approved inspectors.
Right.
Might have been all the chief fire officers as well. They used the list over time changed, and
right.
I don't know for sure which one this would have been circulated.
Right. So very much building control orientated. Was there any reason why it wasn't also sent to architectural organisations or surveyors such as the RACS, the RABA, designers and other construction industry bodies?
I think this was a formal process that had been established for some time, and that was how it was done. The documents are placed on the department's website as well.
Right. Let's then go to page 2, where it says in the first bullet point that the purpose is to draw attention to these amendments and explain the changes they make to the Building Regulations 2000, the Building Regulations and the Building Approved Inspectors, etc., Regulations 2000, the AI regulations. And then third bullet point, announce the approval and publication of 2 new approved documents. And then if you scroll slowly down through to page 10, take this from me, that the circular gives fairly detailed information about the changes to that guidance. And as an author, I think you'd accept that. That's what it does, doesn't it?
Yes.
Yes. Now, so we can see just some examples at page 9 if we go back a page. If you look at C15, there's new guidance there on the need to ensure that management regimes relevant to the building design are realistic. And on page 9 at C17 at the foot of the page, if we scroll down to that, please, you can see that there's something about the provision of self-closing devices within individual flats. At C18 on page 10, provisions for smoke control have been changed and required fire resistance levels for car parks. And things at C19, for example, number of clarifications of existing guidance, including in relation to the use of locks and child-resistant safety stays on escape windows. See all that?
Yes.
Now, we've scoured this document from end to end, Mr. Martin, and we can't find anything in it by way of any reference to any change to the provisions in B4, external fire spread. So take that from me. The question is why? Why is there nothing in this document about external fire spread?
Probably because those changes were made very late on, and this document had probably been drafted well in advance.
Well in advance of what?
Its
of the changes to...
Yeah, and the changes, that they would have been drafted simultaneously.
But it would have been quite easy, wouldn't it, to add another paragraph in here, a matter of moments, just to add another C here, saying we've also broadened the requirement of limited combustibility in the external wall construction to include everything except frames and surfaces.
Yeah, I think if it had come to mind that we could have done that, but clearly we didn't.
No, I know you didn't. And you accept that you could have done. And my question is why? Why didn't you?
I don't recall a conscious decision not to. I think my guess is because those amendments were late on, they didn't find their way into this document.
But wouldn't it have been obvious that if you were going to make late amendments not having consulted on them, nonetheless, at least to alert all the building control bodies at whom this document was directed, that they were there?
I think we should have done, but clearly at the time we didn't think of it.
Well, you didn't think of it. I mean, why didn't you think of it, given that you were actually making these amendments themselves on the eve of publication? Why not simply read across, swivel across to another screen, open another screen, and add a paragraph?
As I say, this was the changes we made in relation to B4 were one of hundreds of changes that we were making.
Was the reason again to keep this as low key as possible and not to alert industry to the fact of the changes in order to avoid a risk of challenge on the basis that it had not been the subject of consultation in the first place?
I don't remember that being something we talked about.
Now, going back up to page 8 of this document, paragraph C8, we can see there it says, under the broad heading of the new approved documents, a summary of the main changes to the guidance contained in both of the approved documents can be found inside their front covers. Now, let's go to that. Can we please go to CLG 1607? This is volume 2 of the 2006 edition as published. And you can see that from the bottom right-hand corner. And if we go to page 2, please, you can see at the top of the page on the left-hand side, volume 2, main changes in the 2006 edition. Do you see that?
Yes.
And if we look over page 2, you can see changes listed to the introductory sections. You can see that, can't you? If you scroll down, you can see in the left-hand column B1, fire alarms in flats, fire alarms, means of escape. And then if we go back up to the top of the screen, it goes straight down to B3. There's no B2. You see that. If you go to the bottom of the right-hand column in the small bold print there, it says main changes are continued on the inside back cover. And if we go to the inside back cover, that's at page 169. Can we go there? We can see the remainder of the changes are covered. And here we do have the second half of the screen, B4, and you've got P and Q, notional boundaries, space separation, and roof coverings in order to incorporate a new European system of classification in 13501 relating to roof coverings there. You see those two changes, but nothing at all there about 12.7 or filler or the exclusions from filler, gaskets, sealants and similar. Why is that?
It wasn't one of those. We listed those things that we thought were most needed to be given prominence. That one didn't come on the list, and I think partially that's because some of those changes were probably late in the process.
You see, given that you'd made amendments to 12.7 by expanding the title and adding the words filler material, not including gaskets, sealants and similar brackets, etc., it would have been easy, wouldn't it, to flip to page 169 or whatever it was in the draft and just add a sentence or two there, wouldn't it?
It could have been. We didn't decide to do that. We probably changed every paragraph in the document.
Was there a deliberate decision at the time not to alert the reader to that change?
No.
So again, you would say it just got missed. And there's no other explanation.
Well, as I say, there are hundreds of changes. This lists some that we'd identified as might be worth bringing to the reader's attention.
But why wasn't 12.7 one worth bringing to the reader's attention, given that it had to do with the combustibility of the external wall? Quite an important one. They're
all important.
Well, they may all be important. I see why you say that. But given that it was a recent one and therefore at the forefront of your mind at the time, why not just pop it in under B4?
Clearly we didn't think of that at the time.
Well, it isn't clear whether you didn't think of it at the time or whether it was a deliberate decision not to put it in.
Well, my evidence is that it wasn't a deliberate decision. I don't recall ever discussing that with Mr. Bird or anyone else.
I understand. Now, after the publication of the approved document, I think it's right, isn't it, that you were, along with Anthony Bird, involved with what he called a dissemination exercise. Do you remember that? Yes. And he says that in his statement at paragraph 32. Is it right that your own work on the dissemination exercise, in fact, formed part of the project to revise approved document B?
Yeah, part of the contract, yes.
Yes. Yes, thank you. Exactly, and just for our record, that's task 3D at page 13 of the contract, BRE 401953. You may remember, we can look at it if you like, but it envisaged that there would be 6 seminars or roadshows between April and September 2006. Do you remember that?
I certainly remember doing a series of roadshows, yes.
You do, right. And did you attend them? You went to those roadshows, did you?
Most of them, Mr. Bird and I spoke at them. It was quite a long presentation. I think between the two of us, it ran on for a good few hours.
Did you attend all of them?
I don't think I did. I'm pretty sure that Mr. Greenwood may have covered some of them. We made a point of getting a number of colleagues to attend the first event so that they could follow how we presented the information, so that there'd be a degree of consistency in the way we presented it.
Now, if we go to your statement at page 35, please, paragraph 106, you say this: the department continued to be aware of the issues concerning external cladding systems throughout the review of ADB that led to the 2006 edition being published. As may be seen from slide 55 of the PowerPoint presentation, which you exhibit, or you refer to, that I jointly delivered with Anthony Bird. I was still at BRE he was at the department, entitled Changes to Part B Fire Safety of the Building Regulations and Approved Document B. The fabric of external wall construction had been an aspect of the review and one which had resulted in changes from the previous version. The slide sets out 2 ways in which the industry may achieve the functional requirements of requirement B4, using materials of limited combustibility or meeting the performance criteria in BR 135 from test data obtained by conducting a BS 8414 Part 1 2002 or BS 8414 Part 2 2005 test. The presentation, it goes over the page, was delivered as part of the post-review drive to educate the industry about the changes that had been made to ADB. Now, can we flip back, please, to the page before, and the first sentence of that paragraph? This is where you say, the department continued to be aware of the issues concerning external cladding systems throughout the review of ADB that led to the 2006 edition being published. Now, first, when you say the department, who are you talking about there?
That would have been the people at the department that I was dealing with, so it's Mr. Bird and his colleagues. Mr.
Bird and his colleagues. And again, which colleagues do you say were aware of the issues concerning external cladding systems?
From memory, I'm pretty sure Tracy Cole was involved in the whole project. I can't remember when Darren Hobbs joined the team. I think he was there.
Okay. Now, when you say the issues concerning external cladding systems, what were the issues you're referring to there?
I think I'm referring generally to the discussions we would have had, for instance, regarding the edge.
Right. Can we go to the slideshow then that you refer to, which I think is what you say was part of the department's drive to educate the industry about the recent changes? This is a CLG 19451. CLG 19451. And that's the first page. You can see it's on CLG heading, background, procedural changes, volumes 1 and 2, and dwelling houses, buildings other than dwelling houses, volume 2. If you go, please, to if you go, the first slide. I'm not sure it's there, in fact, but do you remember that you were one of the authors of this document with Anthony Bird?
Yes.
You were. Did you prepare the slides together?
Yes.
Did you jointly deliver all of these presentations, or did when he wasn't there, did you do it, and when you weren't there, did he do it, or perhaps?
Because it was very long, there was always 2 people presenting, one from the department, one from BRE.
Right, I see. And you're right, it's 59 pages long. If we go to 55, page 55, we can see that this is a slide dealing with external wall construction. If we have that just expanded, and it says in blue, external wall construction, and then it goes on to say insulation materials, stroke products, and then there's a direct quotation from 12.7, isn't there?
Yes.
Yes, or at least the first part of it. And then cavity barriers, section 9, external surfaces, diagram 40, or meet the performance criteria given in BR 135. So just looking at it, you've chosen to quote there the new 12.7, and then just cross-refer to the other elements, cavity barriers, section 9, external surfaces, section 40. Yes?
Yes.
Yes. Now, if we go to your witness statement that I've just read out to you, let's go back to that, please. Paragraph 106. You say there that, and this is 4 lines up from the bottom, the slide sets out 2 ways in which the industry may achieve the functional requirements of requirement B4. See that?
Yes.
Then you go on, using materials of limited combustibility or meeting the performance criteria in BR 135. Why do you say that? Let's go back to we probably need to go back to the slide at page 55 if we can. But why do you say it sets out the two ways in which industry can comply?
I'm trying to explain what's become known as the linear route or the large-scale test route.
But in your statement, you say using materials of limited combustibility or meeting the performance criteria in BR 135. And the reason I ask the question is because if filler was intended not to apply to the whole of the external wall build-up, but only parts of it, retaining diagram 40, it's right, isn't it, that the alternatives weren't materials of limited combustibility or a full-scale test, were they?
I see your point.
Yeah. So why do you say in paragraph 106 that the slide sets out two ways to comply with the functional requirement, when in fact there are, if you ignore cavity barriers, there are three, two of which run in tandem, insulation and external surfaces?
And that's not the way I'd look at it. I think the linear route is a combination of a number of different provisions.
One of which does not require limited combustibility as the standard,
yes.
Namely diagram 40, yes?
I accept your point.
Yes. I mean, is there an element of, was there an element when you wrote your statement of some confusion there between diagram 40 and combustibility, limited combustibility?
No, I think I was just trying to point out that we were explaining both options.
Yes, but both options aren't the options, are they? It's linear or full-scale test, not limited combustibility or full-scale test.
I accept that.
Yeah. I'm just trying to understand how you came to make that mistake when doing your statement. Can you explain?
I don't think there was any ulterior motive in that. I was just trying to explain the two options. Now you mention it, I probably could have described it more accurately.
And again, just to be clear, there's no, I think you'd accept, there's no suggestion looking at the slide that the requirement of limited combustibility applied to all elements of the external wall construction over 18 metres, is there?
That's correct.
No, and that's because, is this right, that you didn't in fact intend that the changes to ADB should have that effect?
Well, we didn't intend, yes, that was the conclusion that we came to as a team.
The we being what? Both you, the BRE, as the contractor, and the department?
Yes.
Yes. Now, the separation of these three matters would tend to suggest, wouldn't it, or to confirm, those looking at the slide, that the word products in the title of paragraph 12.7 was not a reference to all products, but insulation products. Yes?
Well, no, if we said just insulation products, we wouldn't have needed the phrase filler material, not including gasket sealants and similar, etc.
Right. Well, would you accept that there's no suggestion here, by way of explanation, that the phrase, as you can see set out, filler material, etc., was intended to refer to the core of composite cladding panels?
There's not an explanation on the slide. The slide is just quoting the text, but we wouldn't have just put the slide up and let people read it. We would have talked about it.
Well, I was going to ask you, did you address that orally in your explanation?
We addressed all of the slides orally, yes.
Right, and what did you, I know it's difficult and there's no script, but can you remember the gist of what you told the attendees at these roadshows about what filler material, not including gasket sealants and similar, etc., meant?
I can't remember exactly what we said.
Did you explain to these people that the word filler might apply to unspecified components in the external wall construction which you hadn't been able to think of?
I think I would have done, but I can't say for certain.
Right. Do you agree that this presentation, at least looking at the slide, doesn't tell industry that the phrase filler material, etc., was intended to apply to something other than insulation?
If you only look at the slide, yes.
Yes. Did you ask for feedback from your audiences about their understanding of the new text of paragraph 12.7?
No, I don't remember doing that.
Now, given that it hadn't been listed as a matter for consultation, it hadn't been consulted on, it hadn't been put before BRAC, it hadn't been mentioned in the 18th of December 2006 circular, and it hadn't been listed as a significant change on the front or back covers of the new edition. Given all those matters, why didn't you seek feedback from your audiences to see what they thought?
Well, we would have presented this and explained what the text was, what the changes were intended to try and achieve. We were the audience were quite able to raise issues with us if they wanted to. There would have been a question and answer session at the end, but we didn't specifically ask them about this. As you say, it's a very long presentation, so there would have been a range of questions about all of the slides, I imagine.
Right. So is this right, that you left it to the vagaries of a Q&A rather than formally asking them at the end for their feedback on whether or not the changes were clear and understood?
We would have needed to do that for the whole document. I don't think that would have been a practical option.
Well, the difference between the whole document and this part of the document is that this was one part of the document which had not been the subject of any consultation or any publication, whereas much of the rest of the document, if not all of the rest of the document, had. No?
Well, I think there would have been textual changes to, again, most of the document following the consultation. So that the fact that the text in the final document wasn't the same as the consultation is normal.
Right. Now I want to turn to different years, 2008 and 2009. Can we start, please, by looking at CLG 1003572? And if we go to the bottom email in the chain, please, this is an email from Philip Reed to you on the 14th of February 2008. And he says this: Dear Brian, thank you for your time this afternoon. Following on from our conversation, please find below and attached a bit of further information surrounding the issue of concern for the companies Euroclad and Eurobond, who I represent. Eurobond and Euroclad have over 25 years' experience supplying metal external envelope solutions for roofs and walls using non-combustible insulation. They offer built-up systems and composite panels, construction systems that are used on a wide range of buildings, including schools and hospitals. That we have serious concerns about the fire safety surrounding certain types of composite panels and feel that the current standards and regulations need to be reviewed to ensure people's lives are not put at risk unnecessarily. There's a belief that there are loopholes in the existing framework that allow some manufacturers to offer products that are misleading in their sales documentation and are a genuine fire risk to the public. I have attached a very basic briefing paper which covers some of the issues in more detail. You can see the rest of it. There's a reference to LPS 1181. He goes on to say in the next paragraph towards the end, we are very interested to find out the position on this issue from the relevant divisions of DCLG. Within DCLG, if possible, it would also be useful to meet with the right people to see how this can be pursued. Now, we can see from that email that you had had a conversation with Philip Reed that day. Do you remember the conversation?
No.
You don't? Now, if we go up the chain, we can see that you responded to his email that very day, 15 minutes later. And you say this: Philip, many thanks for your email. As I explained today, if you're concerned that a manufacturer is deliberately misleading people with its literature, then this is something that should be taken up with the relevant trading standards authority. I understand that Eurobond have already made such a complaint to the Advertising Standards Authority, and this has in part been upheld. Regards, Brian Martin. And if we look at the top of the email chain, we can see that you forwarded both emails, both his to you and yours in response, to Anthony Bird 4 days later on the 18th of February 2008. Yes?
Yes.
Now, leaving aside for the moment, if we can, Mr. Martin, the Advertising Standards Authority and any specific misleading claims being made by specific manufacturers, when you responded to Philip Reed on the 14th of February, you didn't respond at all, did you, to his wider point that there were loopholes in the existing framework allowing such claims to be made, did you?
I think when you look at his briefing paper, it related to the LPS 1181 testing regime and the application of different types of sandwich panels to low-rise industrial buildings.
Maybe, but my question is about your response. He's identified loopholes in the existing framework, which he said allowed such claims to be made. You didn't respond. I'm just asking you to accept that on the face of it, you're not responding to that, are you?
I may have done in the conversation we had on the telephone.
Right, but you don't recall the conversation?
No.
So you don't recall whether you did or didn't respond to that concern? Or did you?
I can't imagine we would have had a conversation without addressing it.
Right. All right. And what did you tell him? I mean, I know you can't remember the conversation and you're probably speculating, but do you accept this, that loopholes in the existing framework, if there were any, would be properly a matter for the department?
If there were any, if you look at the briefing paper that's attached, it's referring to an insurance industry standard, LPS 1181, and the concerns. The point. I mean, Mr. Reid works for Political Intelligence, which is a political lobbying company. So he's been employed by his clients are manufacturers of rock fibre filled sandwich panels, and they weren't happy that some manufacturers were selling other products that weren't theirs. Right.
And did you, before you responded to him 15 minutes after his email, or perhaps during the period up between the conversation in the afternoon and receiving his email at 4:18 that same afternoon, do any research into the loophole he was referring to and satisfy yourself that there was no such loophole?
I would have read his briefing paper and considered that.
And having considered that, were you satisfied that there was no loophole?
In respect of what he was raising, I believe so, yes.
And did you explain to him that he was wrong in his belief that there were loopholes?
I think I would have explained to him that LPS 1181 isn't relevant to the building regulations, it's an insurance industry standard.
Yes, and he wanted to receive your views on those standards, which he says come from the insurance sector, and that they're being misused, and wanted to know what your position was. What did you tell him?
I can't remember the exact conversation, but as I say, these are standards that aren't relevant to building regulations, so that would have been the answer I gave him.
Right. Let's go to CLG 1003645, please. This is a chain of emails from March, same year, 2008. It's a long chain, so we don't need to go to all of it, but can we look, please, at page 3 at the foot of that page? And this is an email sent by Bill Parler on the 7th of March 2008 to Jeanette Henderson. Now, Bill Parler was, at the time, from the Association for Specialist Fire Protection, the ASFP, wasn't he?
Yes.
You may remember that. And just to give you a little bit of context, Jeanette Henderson was at the department, wasn't she?
Yes.
And this email, I think, and his previous, which was sent on the day before, which we don't need to look at, related to the Code for Sustainable Homes. And again, for context, he had raised concerns that that code made no reference to fire safety or compliance with the provisions of approved document B. But what I want to focus on, having given you that context, is this. If we look at page 3, he says this: Jeanette, thank you for your note. I can easily agree and note that ADB will still apply, but we have a very large dependency on the Class 0 contrivance for building products since the 1960s. This was originally introduced to permit paper-faced plasterboard. Previously, the weaknesses of the Class 0 approach has largely been compensated by relatively robust and traditional building techniques. However, now, with modern methods and sustainability as a buzzword, designers have taken their eyes off the ball. The consequence is that we see massive increases in fire load introduced into the building fabric, often protected by little more than a thin film of aluminium foil. If the foil or alternative covering remains intact, Class 0 can be maintained. If not, then flashover can be reached in seconds. Yes, seconds, not minutes, with combustible lining products. Vulnerable points will occur wherever building services penetrate the combustible materials. It's not just about damaged systems. The prefabricated modular system has similar worries associated with the basic use in innovative design. Regrettably, we are sailing ever closer to a great calamity unless sense and better understanding, underlined, prevails. In recent times, the weakness of over-reliance of the Class 0 approach was demonstrated in the sandwich panel market, where steel sheet covering was used, much more robust than aluminium foil. The large spate of fires, deaths and near-deaths that followed caused Appendix F to be added to ADB as guidance but not as a requirement. Unfortunately, designers have not linked the two issues at all, viz. Hazardous panels and modern methods of construction. Insurers are not increasingly concerned, they are already concerned and contemplating removal of insurability for such buildings. I don't think I need the rest. Now, and he says he's happy to pop in for a chat. Now, this email wasn't copied to you, but it was forwarded to you by Jeanette Henderson on the 1st of April. And we can see that much higher up the chain. If we go to the foot of page 1, it comes through Tracy Cull by a slightly circuitous route to you. And you respond to it at the top of your screen on the 3rd of April. Do you see that?
Yes.
Yeah, so can we take it that you read Bill Parler's email at the time?
Yeah, I must have done, yes.
Yes, thank you. Now, if we can go back to page 4 of the email run and go back again to Bill Parler's email, first paragraph, we can see there that he refers to Appendix F. Can we take it that at the time, this is 2008, you were aware of Appendix F?
Yes.
Yeah. Now, am I right in thinking that Appendix F had been introduced into the 2000 edition of Approved Document B?
I think so, yes.
And that came into force in July 2000?
Yes.
Yes. Yes, we think that's right, because it doesn't, I think, appear in the 1992 version. Now, the guidance in Appendix F, let's go to that. It's at CLG 15012, page 132. It's entitled Insulating Core Panels, and then underneath that Appendix F, and then underneath that, fire behaviour of insulating core panels used for internal structures. Now, then it says, introduction, insulating core panel systems are used for external cladding as well as for internal structures. Can you just explain to us what insulating core panels are in the context of external cladding?
Insulating core panels is another way of saying sandwich panels. So they're typically 2 layers of metal with a core of either an insulating foam or an insulating rock fibre.
Right, and how would they be used in external cladding?
In the way they were used on the edge, as the external face of the building.
Ah, okay. So you would call that, would you, an insulating core panel? That panel that was used at the edge.
I think in terms of this, yes.
Right.
Although Appendix F is focused on their use internally.
When you were searching for a way to deal with the edge problem, as we can see you were after the consultation, did you think to turn up Appendix F and use the words or phrase insulating core panel, which is a signifier for the edge, and apply the material of limited combustibility requirement to that?
I think the problem would have been is it's got the word insulating in it, so you'd assume that it would only apply to things that were there for their thermal performance.
Yes, all right. I see that. What about the word core? Did you not think to look at Appendix F and see that the edge panel was a panel with a core and use the language in Appendix F?
I see your point. No, that's not what we thought at the time.
Yeah, no, I could see that too, but why was that the case?
I couldn't say.
Going back to Bill Parler's email, he refers to the large spate of fires, deaths and near deaths, as you can see. I've read that to you.
Yes.
And it's the middle, pretty much the middle of your screen. Do you see it?
Yes, found
the
it,
large
yes.
spate of fires, deaths and near deaths that followed caused Appendix F to be added to ADB as guidance but not as a requirement. Were you aware of the large spate of fires, deaths and near deaths to which he's referring?
It's not uncommon for people to use hyperbole in this kind of correspondence. There definitely were deaths associated with the use of insulated panels inside a building. There were some firefighters that died tragically. I think it was a chicken frying works where they were cooking chicken on an industrial scale, and there were some foam-filled panels that formed the partitions around the cooking area, and used in that environment, you get a sudden change in the nature of the fire, which the firefighters wouldn't have been able to recognise until it was too late, and so those firefighters were killed, and that's one of the main drivers for why these changes were made. There were some other industrial fires where there were like financial losses, which had been attributed to the use of this kind of insulated or sandwich panel.
If we look back then at Appendix F, if we can just go back to that, please, page 138. Sorry, 13. Let's go to the Appendix F in the 2006 edition. I think it's probably better so we can place it in time. CLG 40740. CLG 40740, page 138. Here's Appendix F again. And if you look at the right-hand side of the text and the third and fourth paragraph in that right-hand column, it says, the insulating nature of these panels, together with their sealed joints, means that fire can spread behind the panels, hidden from the occupants of occupied rooms/spaces. This can prove to be a particular problem to firefighters, as due to the insulating properties of the cores, it may not be possible to track the spread of fire even using infrared detection equipment. This difficulty, together with that of controlling the fire spread within and behind the panels, is likely to have a detrimental effect on the performance of the fixing systems, potentially leading to their complete and unexpected collapse together with any associated equipment. Now, when considering the fire at the Edge in 2005 and 2006 and making amendments to Section 12 of the approved document to address the Edge problem, did you give any consideration to making amendments to the first part of Appendix F, the content of which indicates, doesn't it, that such panels only present a particular problem for fire spread internally?
That's not the approach we took. We took the view that Appendix F was specifically about internal structures. It was a particular issue that had arisen, and at the time the department had produced this appendix, we were trying to produce something that was more generic and not focused on a single product.
Well, yes. I mean, you say you took the view that Appendix F was specifically about internal structures, but it's clear that it isn't, is it? Because, as it says in paragraph 1, and as you've confirmed, they are used in cladding systems, and indeed cladding on high-rise buildings, as in the case of the Edge. Yes? So it wasn't limited to internal panels.
Yeah, but this section is talking about the issues they present when used internally.
Yes, but in fact those issues could also apply externally.
They're different.
Well, maybe, but they're common, aren't they? They're common, and they may be different, they may behave differently, but the problems with sandwich panels with a combustible core when used for cladding would be similar to, or the same as, or at least common with, the problems identified in what I've just read to you. You can't track the spread of the fire.
It's quite a different situation.
Right. Did you consider the language of Appendix F when looking at 12.7 at all?
I don't think we did. I think it's a good point, and in hindsight, I think we could have used the word core as well as a more generic text.
Then let's go back to Bill Parler's email, CLG 1000365. And if you go to the first page, please. I think we need we need page 3 for this. He refers there in the third line of his email to dependency on the Class 0 contrivance for building products since the 1960s. You see that?
Yes.
What did you understand him to mean when you read this email?
I think he's talking about the way that Class O evolved in the 1960s.
Well, he calls it a contrivance. What did you understand him to mean by that?
I think he's referring to the way that at the time they were trying to come up with a classification that allowed certain products and didn't allow certain other products. And I think at that time they were focused on quite specific products that they knew they did or didn't want to be used. And that's how they developed the test. So I can see why you would call it a contrivance.
Yes, I mean, the message that he's giving to Jeanette Henderson and thereby up the chain to you is, isn't it, that Class 0 is no longer a robust standard given its original purpose and given the arrival of more modern methods of construction and sustainability.
I think that's the argument he's making, yes.
Yes. Was that not a very clear warning about the dangers inherent in retaining a reference to Class 0 in approved document B, at least in the context of external fire spread?
That's a view I'd heard other people make.
Yes, at the time.
Yes.
And which other people?
I can't remember. It's a topic that's come up from time to time in the past about the criticism of Class O in its generality, not particularly focused on external wall construction, but just generally.
Well, indeed it had, and indeed we've seen, because we saw it last week, the recommendation of the Select Committee to abandon Class 0 in favour of a much tougher combustibility standard, with an alternative being the full system test, yes?
Yes.
Yes. And did you not read this at the time as indicating that argument, the inadequacy of Class 0 as a classification standard, was still persisting?
It showed there were some people that took that view, but decisions had already been made by then, and the approved document was in place.
What were your views in the spring of 2008, or thereabouts, on the adequacy or otherwise of National Class 0 as a standard to be retained by Diagram 40 and B41 relating to the surfaces of external walls above 18 metres?
I'm not relating to this email, just generally external wall construction.
I'm relating it to the email only in terms of its timing, 2008.
I think I just generally thought this was something we'd need to look at in the future.
When would you need to look at it next?
Next time we reviewed approved document B.
Which was going to be, at this point, when?
Up until the 2006 edition, they were reviewed about, I think the space between reviews varied from about 6 to 9 years, I think.
Yes. In fact, historically, we know that was put on a more regular cycle, and the next review was in 2010, wasn't it?
I think at that so this is after the Future of Building Control report. So yeah, I mean, I'm of the view the approved document should be revised every 5 to 6 years.
Right. At any rate, can we take it that on your radar a review of the adequacy of approved of Class 0 in the context of external fire spread needed to be undertaken the next time there was a review of ADB?
I think the whole fire classification system was something we'd need to look at, because we implemented the European system, and the question about at which point you either removed or derogated in some way the BS 476 system was clearly going to be one of the things that we'd need to consider at some point.
I see. So I think the answer to my question is yes. It was on your radar for reconsideration the next time there was a consideration of the standards.
Yes.
Yes, thank you. Now, if we go then to I'd like to show you what Dr. Crowder told the inquiry. This is at day 229, page 53, please. And if we look together at line 18, he's asked the question, do you consider that National Class 0 has been at any time an appropriate measure of the fire performance of external cladding? And the answer he gives is, when the issue, if you like, was first conceived, then I can understand the argument for using an existing test and trying to make the best use of it, albeit in a slightly different application, using these sorts of principles. But I would say that, and if we could turn over, certainly by the time of ADB 2006, when, we were several years into European harmonisation, for instance, I really struggled to see why Class 0 was retained. I mean, I don't think I did. I gave evidence on the appropriateness or otherwise of Class 0, as opposed to the European tests, during the evidence I gave in Singapore in the Supreme Court back in 2015. And then he goes on, if you go, please, to line 21, to say this. I don't support Class 0 as a test. I understand that there are political motivations as to why it was retained, but those are political, they're not technical. Now, first of all, do you agree with that?
Well, all of it.
Well, do you agree with his evidence that that there were political motivations behind Class 0's retention and not technical motivations? Do you agree with that?
I think it's a very broad. I think I'd need to qualify that. There wasn't a specific political driver to retain Class O or otherwise, in the true sense of the word. At the time of drafting ADB 2006, there was a recognition that you needed to consider more than the surface. That's why the guidance was structured the way it was.
If we go on to page 56 at line 19, question, is your evidence that despite remaining concerned about it, you never raised it, that's with Class 0, with Brian Martin, because you knew the answer would be no? And he says this, I wouldn't say I never raised. We knew there was a shared understanding that Class 0 is what it is and it's not ideal. Yeah. Then that ultimately it would come to an end, but that end got extended and extended and extended. And I mean, it's in some of my evidence, government, and I'm not talking about Brian Martin, I'm talking about people he reported to. They weren't in listening mode at this point. Fire safety was very much in decline at that stage, I would suggest. Now, I've put all of that to you. Is there anything that Dr. Crowder told the inquiry that I've just read to you there that you disagree with?
In generality, I suppose it's a fair observation from his point of view.
Did you share Dr. Crowder's understanding that Class 0, as he put it, is what it is and it's not ideal? Did you share that understanding with him?
Specifically for external wall construction or generally its use?
Well, the context here is specifically for external wall construction.
I think at the time at the time of drafting the ADB 2006, we'd come to the view that you couldn't use it in isolation. That was the point of the way we'd structured the guidance. And in more general terms, we knew that the BS476 series of tests would eventually be withdrawn.
Now, that's not the first time you've used the expression in isolation or couldn't be used in isolation. What do you mean? In isolation from what?
So Class O is fine for assessing the via properties of a product at its surface, but won't necessarily tell you what's going on beneath the surface, which may be relevant in some circumstances. Which is why ADB 2006 talks about external wall construction generally first, talks about the risk of using combustible materials within a cladding system, and then points you to consider both the surface following diagram 40 and to consider insulation, fillers, etc. inside the construction.
Now let's go then to CLG 000019508. This is March 2008. Could I just ask you before I take you to that, do you remember having a discussion with David Crowder at around this time, March 2008, or any time in 2008 or so, about the inadequacies or otherwise of Class 0?
No.
Looking at this email, if we go to the second email down in the chain, we can see that on the 20th of March 2018, Larry Cody sends an email to Anthony Bird, and just to orientate you in the email run, if you go up to page 1, to the top of page 1, you can see that Anthony Bird sends it on 5 days later, 25th of March, to Tracy Cull and you, yes?
Yes.
Please deal, he says, and I'll come back to that in a moment. I'm showing you that just to remind you that you saw the longer email from Larry Cody sent to him, Anthony Bird. If we go back to page 1, to the foot, he says this, and you need to look, please, at the second paragraph down, halfway down that paragraph, where he says, having witnessed the speed and extent of damage resulting from fires in buildings during recent years, we share the concern that traditional methods of evaluating risk may not be sufficiently adequate in their current form to be applied directly to alternative construction methods and products. Indeed, we believe that in certain circumstances, new and possibly larger scale tests may be necessary to adequately assess the performance of a construction system, such as the relatively new BS 8414 tests for spread of fire on facades. Now, when you saw this email, did you understand by the reference to the term traditional methods of evaluating risk that Mr. Cody was expressing a concern that Class 0 was inadequate?
I don't remember this email, so I don't remember thinking about it.
Now, we know that, as I've shown you, Anthony Bird forwards the chain to you and says, please deal, if only to say, we go up please to that, if only to say that any work we do let, and it is not all for us to support stroke pay for, will be guided by the necessary steering group. Thanks, Ant. Now, that suggested response is something of a brush off, isn't it?
The difficulty you have in situations like this is you can't set out what you think as an official, because that would be perceived as being the department's opinion, and the department essentially wouldn't have had an opinion at that point other than to say there's some research that is looking at it.
Well,
so you can't go back to him and say yes, I agree, because the department hasn't made a decision which eventually gets, the government seal of approval. So you're always having to be very cautious about agreeing or disagreeing with a point that somebody's making if it's pointing out to what we should do in the future, because that's a decision that's yet to be made.
Right, but he doesn't suggest that you tell him just what you've told us. He says, please deal, if only to say that any work we do, etc., will be guided by the necessary steering group. And I'm suggesting to you that the right characterisation of the suggested response is a brush-off. You're not actually going to deal with the nub of Mr. Cody's concerns.
Well, I disagree. That's the best answer that you could give within the constraints as an official.
Right. we can't find any written response to Larry Cody. Do you remember whether there was one?
No.
You don't. What consideration did you give to the broad concern that Mr. Cody has raised here about the adequacy of Class Naught or traditional methods of construction?
I think it's a general and ongoing debate about how standards need to be developed to try and interact with changes in construction technology.
Right. Now, I'm going to turn to a different topic next, and I'm going to look at the period from 2012 and ask you about a number of major fires involving external fire spread on high-rise buildings internationally in the period 12 to 14. Can we start, Mr. Martin, with your statement, please, page 36, para 109. And here you say this: on the 17th and 18th of May 2012, I was sent links to a tower fire that had taken place in France. In reading about the fire and responding, I remarked that this wouldn't be in accordance with building regs, probably. By this comment, I intended the same as that which I think David Crowder of BRE implied by his comment in the other contemporaneous email chain. Maybe post them a copy of BR 135. My understanding at the time was, and remains, that if the functional requirement of the regulations and the guidance in ADB is adhered to, high-rise blocks should not be clad in such a way that leads to a fire like that which had occurred in France. I use the word probably, as I did not have anywhere near enough data to assert definitively whether the French block would have been compliant with requirement B4 or not. Now, I think it's right, isn't it, that the fire that you're referring to here was the fire at Mermoz Tower in Roubaix in France on the 14th of May 2012? I
believe so.
And if we look at one of the emails that you're referring to, we I think, see this. It's CLG 3019179. There's an email below it. Hello, French was quite rusty, with some embedded photos and videos. And then you, on the 18th of May 2012, you send an email to Louise Upton, Peter Wise, Ken Knight, copy to Anthony Bird and Stephen Kelly. Subject is fire in France this week. And you say this: for info, the video on the second link is pretty alarming. This wouldn't be in accordance with building regs, probably. And that's the bit you quote in your statement. Now, why did you need any data in order to make any analysis? Was the image of the external fire spread not enough to tell you that the external wall at Roubaix did not adequately resist the spread of fire over the surface of the walls?
Yeah, I think when I'm saying didn't comply, wasn't being in accordance with building regulations, I'm referring to the guidance in the approved document alongside the functional. Clearly, it doesn't meet the functional requirement.
No, but you wouldn't need data for that. You'd just look at the video and see that, wouldn't you?
Yeah, but what I would have liked to have known is had a better understanding of the form of construction.
Did you later find out any more information about the form of construction or what had caused the fire?
I don't think so. I think this was the best information we managed to get.
Did you ever find out what kind of cladding products were involved or whether the external wall arrangement, in fact, as built, would have complied with the provisions of approved document B?
No, I think we often struggle to get useful information from fires in other countries.
Did the department, you in particular, make any effort to do that?
I can't remember at the time. We would have asked BRE if they had any contacts over there. It's often quite, immediately after an incident, it's often quite difficult to get reliable information. The information that's in the press is invariably inaccurate, and the authorities in different states will often be very cautious about sharing information because there's a potential there may be some sort of prosecution or something. So it's quite difficult to get useful information on this kind of thing.
Right. Did anybody think of making a government-to-government request?
I don't think so, no.
Why is that?
That's not something we'd have. I would regard as a regular thing to do.
No, maybe not, but nonetheless, an alarming fire, external cladding implicated. I take it not something that crossed your mind?
I was probably working on other things at the time, so I would have had a limited amount of time to look at this.
Did you become aware at some later stage about what the panels on that tower were, whether they were ACM panels with a PE core?
I think I know now that they were ACM, but I don't think we knew that at the time for sure.
When did you discover that they were ACM?
Probably in the last 4 years.
I see. Now, did you consider, as David Crowder had said, that posting them, whoever them was, a copy of BR 135 would have been helpful?
No, I think they would have found that incredibly rude. I think that's just him making a quip.
Yeah, I was going to say, it was just a bit of flippant banter, wasn't it?
Yes, yeah, I think he would have considered that appropriate.
Right. And before this fire, had you become aware of any other major cladding fire outside the UK?
I can't remember the chronology. There's been some in a number of different sites around the world.
Let's go to CLG 3019192. If we go to the bottom email in that email chain, please. This is an email. If we go to the foot of the chain, you can see this is an email from Al. I'm assuming that's Al and not A1, but Al at Rushbrook Consultants in Strathaven, in Scotland. And the email is forwarded by Sam Greenwood to you and Anthony Bird on the 5th of December 2012 under the heading Meeting in December and Tamwheel Fire Report, in quotes. And the email itself says this: Hi Ian, currently in Abu Dhabi and saw the initial reports of the police fire investigation, quotes unquotes, into this tower fire, and then there's a web page there. Once ignited, the fire quickly spread up the highly flammable building cladding, which contained aluminium and fiberglass, to the roof. Triple question mark. I'm back on the 12th, so how about a meeting for a beer and pizza on Monday the 17th or Tuesday 18th December for anyone who's interested? And if you go up that chain, you can see that the email is forwarded to you on the 5th of December. FYI, sounds like the Edge fire in Manchester that signalled the end of rain screen cladding, in quotation marks, ... And at the top of the chain, you respond to Sam Greenwood the same day and say, yes, have you seen the video? It's awesome. Now, I think as we can tell from the title of the email chain, this was the fire at Tamwheel Tower, which occurred on the 8th of November 2012. Yes?
Yes.
Yes. Now, what did you know or come to learn about the cladding panels which were involved in the Tamwheel Tower fire?
I'm not sure when I found out, but I'm pretty sure it was ACM.
And if we look at your statement, you say page 37, paragraph 110. We don't need to look at it all, but you describe the exchange you're having here with Sam Greenwood. And you say there in the third line, I responded remarking on the awesome power of the fire. It remained my view that such a situation should not occur in England, providing ADB was applied correctly. And then you go on to say what I read to you earlier about the edge being taken into account. You'll recall this is a paragraph we saw earlier this morning. The awesome power of the fire is what you referred to. And you say, as I've shown you, that it was your view that such fires should not occur in this country, providing ADB was applied correctly, and that the lessons had been taken into account in the 2006 edition. Was that your view at the time? In other words, at the time of the Tamwheel Tower fire, that kind of fire couldn't happen here because you'd added the words filler material, etc., to paragraph 12.7 of approved document B and added the words /products to the title?
But it's a little more than that. It's the entirety of that section, so 12.5 onwards. But yes, that was my view at the time.
I see. So just to be clear, you understood at the time, your view at the time was that Tamwheel couldn't happen here because of the revisions of 12.7 I've referred to, taken together with the two sentences at the beginning of 12.5 that we read earlier.
Yeah, well, it shouldn't happen, assuming people had followed the guidance as we'd intended.
Yeah. Now, were you aware at the time, therefore, that the fire at Tamwheel involved PE panels, PE cord panels, or at least composite panels with a combustible core, in order to be able to make the link with the word filler?
I'm not sure when I found that out, but it seemed likely.
Right. I mean, my question really is a slightly more precise one than perhaps I've put. Was the reason why you thought that the Tamwheel fire shouldn't happen here because of the general words in 12.5, or because of the specific introduction of the words filler, material, etc., into 12.7?
I think it's the combination of the two.
A combination of the two?
Yes.
How do they combine to indicate that the core of a rain screen panel should be non-combustible, or limited combustibility?
It goes back to the point I was making when we drafted that text, is we were trying to get people to think beyond just insulation.
Right. And one can understand saying that if the functional requirement had been met, then it shouldn't happen. But my question is, how would following approved document B mean that it shouldn't happen?
You'd read the general warnings about using combustible materials. You'd look at the provisions that talk about insulation, fillers, etc., and say, I wouldn't include a layer of polyethylene in the formation of my construction.
Given the seriousness of the fire at Roubaix and now at Tamwheel, did it occur to you at the time that heavy reliance would have to be placed on a particular phrase, just 3 words in reality, filler, material, etc., in order for it not to happen in England?
My view at the time is what I said. I thought that guidance was
right.
Adequate.
And in coming to the conclusion that it shouldn't happen here because of ADB, did you think it was sufficiently well understood that that was the case, universally across the piece, across industry, even though that phrase had never been subjected to any of the ordinary processes for change, for guidance? No public consultation?
At the time, I thought it was okay, yes.
Right. Notwithstanding the absence of a definition, absence of public consultation, absence of BRAC scrutiny, absence of clear identification in the circular of the nature of the change?
Yeah, the answer's the same. At the time, I thought it was okay.
Now, you say in the last sentence here, I'm unsure why Mr. Greenwood stated that the fire had signalled the end of rain screen cladding. Rain screen cladding continues to be used to this day. Did it surprise you at the time that he'd said what he'd said?
I don't remember thinking about it at the time.
Right. Do you remember whether you asked him what he meant?
No, I mean, it was... I didn't. I mean, we didn't work together anymore, so he just dropped me a line with some information he thought might be useful.
Yes. Isn't it, I mean, it's a striking thing to say, isn't it, that the fire signalled the end of rain screen cladding. Did you not want to know what he meant, or why he thought what he thought?
I don't remember thinking that at the time.
Were you aware in the period between 2012 and 2014 of any other major fires internationally involving significant external fire spread?
As I said, there were a few. I can't remember the chronology. There's a handful of fires that occurred in various places around the world. There's one in Australia. I can't remember what year it was.
Yes, that was, I think, late in 2014 at the La Crosse building, right. November.
Yes.
But I can give you a chronology. The Al Baker Tower in Sharjah, January 2012. Al Tayer Tower, Sharjah, April 2012. The Polat Tower in Istanbul, July 2012. The Saif Belkhaza building in Dubai, October 2012. Al Hafid, Sharjah, April 2013. Shangri-La Hotel in Ulaanbaatar in September 2014, and the Lacrosse Building in Melbourne in November 2014. That's the chronology in those 2 years. Were you aware of all of those fires, or only some of them, do you think?
I think only some of them.
Right. And do you remember which in particular from the long list I've read to you?
I couldn't say.
Right. Were they principally those in the UAE, do you think?
I certainly remember the conversation being that there seemed to be an issue in the UAE with a particular material.
Yeah. And you remember, I think, the Lacrosse fire, because you referred to that.
Yeah, I had limited information about that as well. It's very difficult to work out what I knew then and what I know now. And as you might imagine, over the last 4 years, we've looked into this. We've been able to look into this subject in more detail. As a department, we rejoined an international group that the department had withdrawn from some years before, which meant that we better connections with other nations outside Europe.
You say you rejoined it. Did that mean that you were part of an international group but had come away from it?
Yes, I'm trying to remember when it was. It was very early after I joined the department. I've forgotten. It's got a very long title, but there's a group of countries mostly that use a functional or performance-based approach to building regulations, and that includes countries like Australia, but also Scotland and England. It's spread, and New Zealand. I think there's about 8 or 9 different member states, and I think at some point shortly after I joined the department, it was decided that the cost of being involved in the organisation was too high, and so it was decided to withdraw.
So was that after 2008? You say after I joined the department.
I think it was after I joined the department.
Do you mean full time? Well, do you mean joined the department full time?
Yes.
Right. And did you know who made the decision to give up membership of this group?
I think it was whoever was deputy director at the time. I couldn't say for certain.
How much did it cost to be a member of this group?
Most of the costs involved is delegates attending meetings. Because of its nature, sometimes those meetings are a long way off.
Right. Do you remember whether there was intel, circulars, publications that came from the group to keep the British government aware of other fires?
I think it's very constructive. One of the problems you have as working in the job of the lead official, if you like, for building regulations on a particular subject, is there's no one else in the country doing the same job as you. So having links to people doing that job in other countries is useful. And certainly after the Grenfell Tower fire, I think actually it was one of the recommendations that Dame Judith's report included. The department rejoined, and until I left and moved to another post, I found that connection useful.
Yes. I mean, finding it useful after the fire is one thing. Why didn't you find it useful to rejoin after the intelligence about the UAE fires had started to filter through the department in 2012?
I think the budgets were extremely limited then, so asking to rejoin at that time would have fallen on stony ground.
Right. Now, do you remember discussing these fires in the department at the time, or seeing any evidence about them? Photographs, videos, reports?
Just a few brief conversations, really.
Right. What about conversations with BRE colleagues, or as it was then, former BRE colleagues?
I think certainly for some of them, we did ask the team that's working on investigation of real fires to see if they could use any of their international contacts to get more information. But again, that contract was quite limited in the amount of resource it had.
Sarah Colwell told us that she did discuss these international affairs with you at a meeting on the 30th of January 2014, and that had come up in conversation. Do you remember that?
I don't, but it seems likely.
Right. Were you aware that some of these fires had been reported to the department, specifically in reports submitted to you by the BRE under the investigation of real fires contract?
Yes.
And I think the Polat fire, the Tamwheel Tower fire, are two examples of that. Did you read the reports where they had been identified?
I would have done, yes.
Right. Did you make the link between those fires and the use of ACMPE products in this country?
Not at that time, no.
Did you at any time during that period make any link between those fires and the full-scale test carried out at the BRE in 2001 under CC 1924 on the aluminium PE cord system?
As I said yesterday, I mean, I only had sort of second-hand information about those tests, and I remember Dr. Carwell explaining the mechanism by which what I now know to be ACM behaves, and assumed it was that material being used in other countries.
When you say you had second-hand information about those tests, in fact, you had access to the reports, didn't you? Because you were both at the BRE and at the department in September 2002, and had access at least to the analysis report and the closing report, which spelt out what that
I suppose I had an access to a library of information, but I didn't read all of it.
And you also had access to it when drafting BR 135 in its second edition. So you had the means to knowledge, didn't you?
I could have done. Certainly when I was working on BR 135, I was listening to what Dr. Caldwell was telling me and working with her to try and develop the text. So I guess at the time I didn't feel the need to look at that data because she'd produced it.
Mr. Chairman, just two more questions before I can finish the line, if I may.
Yes, very well.
Thank you. Now, given that ACM panels with a PE core achieving class 0 had been subjected to the full-scale test in 2001 on the basis they were at that time in use in the UK built environment, when you learnt of this spate of cladding fires in the UAE, or internationally perhaps, including France, did you consider that there might be buildings here in the UK which had been clad in ACM with a PE core before the words filler material, etc., and the other amendments had been introduced into approved document B in 2006?
I think the view I had at the time was the test that Dr. Caldwell had carried out was on an innovative product. I wasn't aware that it was in use in the industry, in wide use at the time, and that as a result of the test, it probably wouldn't continue to be in use.
Right, but
I have no evidence of that, but that's what I had in my mind at the time.
Did you not think, though, that if the problem of combustible cord rain screen panels was the problem, or one of the problems, that the amendments to ADB by 12.7 was seeking to achieve, that there might very well be some high-rise buildings in the United Kingdom on which rain screen panels with a combustible core had been applied above 18 metres before the amendment to ADB in 2006?
I don't think I gave that direct consideration, but it's whenever you change the guidance to the building regulations, there will be buildings that were built before that might not reach that same standard. That's kind of the nature of progressively trying to improve standards.
Yes, but did the fact of these fires, their awesome power, the rapidity of external fire spread not lead you to think that there might well be a population of such buildings in the United Kingdom which predated your amendments to approved document B in 2006, so that it could happen here?
I don't remember thinking that.
And I'm assuming, therefore, on that answer, that wasn't a subject that came up for discussion with the other officials in the department at the time, 2012 onwards.
No, something I've asked myself several times is whether we should have looked harder at that time.
Mr. Chairman, I'm sorry to go on to 1:05, but that's a convenient moment.
Yes, that's right, Mr. Millett. We'll stop there. Mr. Martin, we'll break now so we can all have some lunch. We'll resume, please, at 2:05. And as before, I have to ask you not to talk to anyone about your evidence or anything relating to it when you're out of the room. All
yes,
right?
sir. I understand.
Thank you very much. Would you go with the usher then, please? Thank you very much. 2:05 then, please. Thank you.